All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Mr. Mitri, please continue.
Thank you, Mr. President. Your Honors, as I said earlier, my next topic is the evidence we submit was fabricated in this case. And we submit it's a result of the prosecution's negligence. And this, Your Honor, is an important part of the defense strategy and the defense theory. So for the next hour, I will use several items of evidence that are on our list of evidence and several defense witnesses who will illustrate what we submit happened. And before I continue, I'm reminded that two of our interns joined us, Lison Grunut and Alexia Legault. So before I go into details in those items of evidence that we submit were fabricated and submitted to your honors, let's go back in time. Because we believe the same mistake happened again. In March 2012, the trial chamber issued its judgment against Mr. Lubanga, who was charged with enlisting children under the age of 15. And the chamber said that it was of the view that the prosecution should not have delegated its investigative responsibilities to the intermediaries in the way set out above, notwithstanding the extensive security difficulties the prosecution faced. But they did it again. They delegated their investigative responsibilities to prosecution witness 2018 and to intermediary 2580 without meaningful supervision. And like in Lubanga, the intermediaries worked simultaneously for the prosecution, for an NGO that worked with children, and assisted victims to participate in these proceedings. The same modus operandi. Did they learn any lesson? No. Because and we believe that they were more negligent because your fellow judges in Lubanga warned them not to do it again, informed them to look into an Article 70 investigations. So they had to apply more scrutiny given the past experience. And to illustrate their negligence and lack of diligence, I will use an item of evidence that is now on your honor screen and that is also on our defense list of evidence. So on our defense list of evidence, we have included the following report from the Bangui Forum. The same Bangui Forum the prosecution attended. In 2012, when the Lubanga trial judgment was issued, the prosecution was already aware that fraud and falsification of birth certificates was something to be alerted to when charging someone with enlisting and conscribing children under the age of 15. So when they attended the Bangui Forum, they should have seen this red flag. They should have been alerted to the issue. Fraud and falsification of birth certificates was something to be aware of in Central Africa. It was a factor affecting the reliability or quality of the Central African administrative record. Something to keep in mind when they were receiving documents, birth certificates by car nationals. And bearing that in mind, I want to show your honors another item of evidence that is up on your screen. An item provided to the prosecution by intermediary 2580, but that concerned prosecution witness 2475. The prosecution had delegated its investigative activities to intermediary 2580. They had tasked him with collecting various documents to show the age of prosecution witness 2475. And they delegated their investigative activities without meaningfully supervising him. When intermediary 2580 brought this tampered baptism certificate, they should have immediately suspected something was wrong. I remember when it was first disclosed, I opened it and I thought to myself, it's suspicious. I actually used the same words as you did, Mr. President, when we first used it in court. Suspicious. But I did not want to influence any member of my team, so I called Ms. Whittingham, and I told her, we received something, I wanted to have a look at it. She came to my office a few minutes later, and she said, well, there's something wrong. This is tampered with. So we went back to the basics. Where did the document come from? A specific parish in the Lobai. So we sent a member of our team there. And what did we find? The book where all the baptisms were recorded with the corresponding number. And indeed, the year 1994 was written, and not 1999, like the tampered document the prosecution submitted. The document that's now on your screen is also on the list of defense evidence. And when you, Mr. President, asked, was this book available to the prosecution? I said yes. It was there all along, the basics. But they were not diligent. They let themselves being fooled by their intermediary, 2580. Although Lubanga should have been a lesson regarding intermediaries and fabrication of child soldier, they did not learn their lesson. So prosecution intermediary 2580 spread. The virus spread like a nasty infection. He infiltrated VPRS, he infiltrated LRV, and worse, Mr. President, Your Honors, because on the basis of that falsified year of birth, 1999, VW made a passport containing false information such as this one. The passport's on your screen. An official document at the request of the court. But at least you asked the prosecution to investigate because you were concerned. So it was only after being ordered by you that the prosecution went back to the basics. They sent a team to the exact same place as we went. And they took a copy of the same registry book, which is also on our defense list of evidence. And the book confirmed that our evidence was authentic and that theirs was false. You have on your screen the copy the prosecution obtained after prosecution witness 2475 testified, once you asked whether this was available to the prosecution. But this was not enough for them. The fact that their star witness, alleged child soldier, had fabricated evidence and lied under oath was not enough to convince them. Remember, they wanted systematic conviction on all charges, so they continued to suffer from the tunnel vision. And just before I move on to the insider witnesses with whom they did not want to test their evidence, the evidence of 2475, I want to pause here for a second and draw your Honor's attention to another point. The prosecution confirmed, as you saw from the document, that prosecution witness 2475's baptism certificate was dated 1994, although the intermediary brought one with the year 1999. The same year prosecution 2475 had given them when they took his statement, and the same year he had testified again and again. And in addition to that, the prosecution had informed the defense that they had not given the intermediary the year 1999 when they tasked him to go and collect documents to prove the year of birth of 2475. So when they confirmed that the intermediary had brought them a document that was tampered with, they could have gone further and started to check into 2475 to see if he was involved with tampering of evidence that would affect the integrity of these proceedings. We would at least have expected the prosecution to obtain Facebook records of 2475, phone data. We would have expected the prosecution to make equal efforts as the one they did when they suspected prosecution witness 1847 with interference. They went to such an extent with prosecution witness 1847. They obtained call data records, Facebook records. They dedicated resources because they believed prosecution witness 1847 did not deliver its incriminating evidence contained in his statement because of interference. But to date, we received not a single disclosure to show they looked into prosecution witness 2475 after realizing that his baptism certificate was tampered with. The integrity of the proceedings, Mr. President, Your Honors, should be protected, whether it means bringing incriminating or exonerating evidence. Let's now move on to the insider witnesses with whom they did not want to test 2475's evidence. And this will again inform you of what would have been revealed had the prosecution verified its sources. They asked insider witness 1647 whether he knew the name of 2475. He answered no. So the prosecution panicked and they moved on, and they didn't ask the same question to the following insider, prosecution witness 1786. Instead, they put to prosecution 1786 the alleged nickname of 2475. I won't give the nickname because we're in open session, but the nickname's on your screen. And 2475, being very intelligent, picked an extremely generic nickname in Central Africa Republic. Nothing unique. So insider witness 1786 says, well, I heard that name, but, and I quote, if you showed me a picture, a photo, I'd be able to recognize him. But the prosecution moved on. They did not want to show the picture of prosecution witness 2475, although they had it, because 2475 had self-identified himself on that picture. They did not want to test their evidence. And this is what we intend to show you during the defense case as well. They could have shown a picture to all three prosecution insiders, 1647, 1786, and 1839, but they didn't. And this is not a simple oversight. It's a pattern. We saw the prosecution doing it during its investigations. We saw the prosecution doing it during its interview with 1839, an insider. In March 2020, they showed her a blurry picture of prosecution witness 2475. It's the one on the left-hand side of your screen. So she answered that she was unable to identify the individuals due to the bad quality of the picture. So the prosecution moved on, not showing the clear picture of prosecution witness 2475 to test their evidence. And they had the clear picture. It's on the right-hand side of your screen. It was in the prosecution's possession, and prosecution witness 2475 had recognized himself a year prior, in May 2019. Searching for the truth means testing your evidence. The prosecution kept dancing around this issue, failing to meaningfully test 2475's central claim to have been a child soldier in the group with its own insider witnesses, its 3 prosecution insiders, failing to show the picture of 2475 that they had from the beginning, because it was a prosecution exhibit. It's not a coincidence. It's a strategic decision from the prosecution not to test their evidence. But defense witnesses, defense witness 6016 will recognize 2475 on this picture, the one on the right-hand side. But she will add an important detail, that he was born in 1994, and that his mother was not dead, as he claimed she was. Defense witness 6016 will also confirm that 2475's mother provided additional pictures of her son. Pictures of him at the time he claimed his mother passed away. Pictures he gave himself to her mother, to his mother. In addition to the defense witnesses, we also intend to submit to your honors various evidence, various items that will show how prosecution witness 2475 and other former prosecution witnesses fabricated evidence in this case. To discover this network of individuals who fabricated evidence, we went back to the basics. So in addition to calling the key figures of Mbaiki that were mentioned by several prosecution witnesses, and in addition to go and search for neighbors of the Boeing Mosque, we also went to search for school archives, parish archives, because they form part of basic investigative steps, which the prosecution neglected to take. We had learned the lessons from Lubanga. The defense case in Lubanga challenged the age of certain witnesses by searching for school records. So we did the same. We started to look for school records ourselves. And unlike the prosecution, we didn't delegate our investigative activities to intermediaries without control and meaningful supervision. So we will present to your honors during our defense case various school records relevant to count 29 and relevant to our submissions that the evidence in this case related to child soldiers was fabricated. Our defense list of evidence contains a certain number of school records and a number of defense witnesses who are school officials will testify on the identity of the school grade of prosecution witness 2475 or CLRV1 witnesses. Their evidence also authenticates several items of defense evidence that we intend to submit to your honors. What other basic information was out there for us to search for? Public Facebook pages. And we found interesting information. For instance, that the main prosecution alleged child soldier, prosecution witness 2475, opened his Facebook page in 2019 and recorded his year of birth as 1994, not 1999, as he claimed in order to pretend having been a child soldier. The item is on your screen and is also part of our defense list of evidence. The main prosecution witness, who was cited 43 times in the document containing the charges and 67 times in the prosecution trial brief, and relied upon heavily during the prosecution's opening statement, had that information out there, available to the public, in his Facebook account. The prosecution neglected to look, wasn't diligent. Although when it came to build its case and search for incriminating information, the prosecution did make an effort. They sent numerous cooperation requests, and they obtained nearly 50,000 pages of private Facebook material. But it's on the basis of these basic means, the public Facebook pages, that we eventually discovered the real identity of another alleged child soldier, former prosecution witness 2620. And it's on the basis of these basic means, the public Facebook pages, that we eventually discovered that former prosecution witness 2582 had recorded in her Facebook page that she was born in 1992, which made her over 20 years old in 2013, far from being a child soldier. So we were using basic Facebook searches on publicly available material to discover the same pattern as Lubanga, that child soldiers, alleged victims, have been lying on their age. So defense witness 6039 will say that she was born in 1995, and that former prosecution witness 2582 was older than her, which corroborates 2582's Facebook showing her year of birth as 1992. The other basic step the prosecution neglected to take is that they didn't properly investigate the relatives. Sometimes they never even looked into it at all. For prosecution witness 2475, for instance. And even when they did interact with relatives, they failed to do so in accordance with their statutory investigative duties, due diligence, such as with 2582's mother. The name of the relatives of prosecution witness 2475, such as defense witness 6018, were indicated in his statement. The prosecution neglected to go meet defense witness 6018 and ask him about 2475 before bringing 2475 as a witness. In fact, they neglected to meet any family members of this witness, but we did. It was one of the first things we did. But before doing so, we had to ask the prosecution to lift the redactions of the name of the relatives of their alleged child soldier, because most of them, if not all, were redacted. Again, not testing their own evidence and creating additional steps for the defense to test it. We nevertheless managed, and our defense team obtained a statement from defense witness 6018 and also from defense witness 6016, another relative of 2475, who will confirm that prosecution witness 2475 was born in 94 and not in 99, as he claimed time and time again under oath. Both statements are part of the defense case. And again, these are the basics, meeting the relatives of an alleged child soldier. It was there, under their nose in the first statement, but they did not meet them to test their evidence. The same with prosecution witness, former prosecution witness 2582. The prosecution submitted her birth certificate into evidence, And again, they delegated its investigative steps, this time to the mother of 2582. They could have asked prosecution witness 2084, their own witness, to confirm the authenticity of the birth certificate before submitting it to your honors. Because 2084 could, he had extensive knowledge about the town hall where that birth certificate was issued, and he could recognize the signature on those same birth certificates. And because the mother had specifically said that she had obtained it from him, as you can see from the document on your honor's screen. But prosecution witness 2084 had the honesty to tell your honors when he came to testify that they were false. But he did so during the defense examination. So not only did the prosecution neglect to ask him about those birth certificates once they obtained them in the field, but they did not even care asking him when he came here to testify. We discussed how the prosecution strategically chose not to test his evidence with its 3 insider witnesses. But the prosecution doesn't want the defense to test it either. You will recall, and several of those birth certificates are now part of the defense list of evidence. You will recall that during the testimony of prosecution witness 2082, Ms. Gise put to the witness multiple authentic birth certificates that are now on our list of evidence. The prosecution objected at the time, saying, and I quote, I don't think it's fine to predicate questions on material that's not in evidence yet before the chamber. It hasn't been tested," end of quote. And then the prosecution went on regarding electoral cards that we had on our list of evidence and birth certificates that we had on our list of evidence, and said, and I quote, "That's not the evidence in the case as yet. That's not fair," they said. So basically, the prosecution strategy is not to test their evidence during their investigations, not to test it during their examination in chief, and to object when the defense is testing it. But the defense case will test the prosecution's evidence. And we will demonstrate during our defense case that the prosecution's failure to test its evidence distorted the narrative of the relevant events that were presented to your honors. And the prosecution will tell you it's not relevant because 2582 did not testify and 2620 did not testify. It doesn't matter. We withdrew them. It does matter. Why? Because first of all, it shows a pattern when it comes to charge 29 and related evidence. A pattern that should have alerted the prosecution. And second, because of Mr. Yekatom's statutory rights. The statute provides him with time and facilities to prepare his defense. So for over 2 years, he used time and resources provided to him by the statute investigating these witnesses, not only on their age, but on the various locations and events described in their statement, on the various individuals referred to in their statement. And your honors will recall that the prosecution withdrew them at a very late stage of the trial. We investigated the publicly available material. During our defense, we investigated and met with witnesses in the field and consulted archives. That's how we were building our defense. We drafted and filed cooperation motion when we started to see the collusion and a scheme among those witnesses and intermediary. And the allegations of those individuals were different from the statement they had given to the prosecution, different from the applications for victims they had signed, and different from some investigator reports that we had received. So we had to orient our investigations to build our defense in various directions. Time and resources on witnesses who we will submit during our defense case fabricated evidence against Mr. Yekatom because they wanted a better life, relocation. There's another reason why it matters. It matters because in Lubanga, the trial chamber, Proprio Mutu, stated that it would be unsustainable to allow victims to continue participating if a more detailed understanding of the evidence has demonstrated that they no longer meet the relevant criteria. So the prosecution could have been transparent because 2582 and 2620 are still participating victims, and prosecution witness 2475 recently became one. They're still CLRV1's client, and the prosecution continued to let them participate in these proceedings. And that is also what the defense evidence will show. You will hear from defense witness 6024 and 6039, who will corroborate that former prosecution 2582 was part of a scheme. And you will also hear other defense witnesses like 6010, 6012, 6019, 6017, discussing the extent of evidence, the extent of fabrication of evidence and collusion, and stolen identity, in which former prosecution witnesses 2620 took part of. And the defense evidence, the defense case, will demonstrate without any doubt that these participating victims no longer meet the relevant criteria, as they were never under the age of 15, or they were never part of Mr. Yekatom's group. But somehow, they're still benefiting from public funds of this court. And most importantly, Mr. Yekatom is still charged with count 29 and being detained, notably because of accusations from those witnesses. So during the defense case, you will also hear about prosecution intermediary or prosecution witnesses or sources who went to such an extent to fabricate evidence in this case. You've already heard about prosecution witness 2018, as well as 2580 and 2638. They were a virus that infected this case, a virus that spread and infected the common legal representative of victims of child soldiers, the victim participation and reparations section, and the victims witness unit. And defense witnesses will present to your honors, like defense witness 6025, 6036, know that prosecution witness 2475, 2582, and 2620 left Central Africa. And the prosecution didn't even inform the legal representative of victims that there was an issue. And I'm not going to spell it out in public, but it's on your screen. An issue with their common intermediary, 2580. Meanwhile, the other virus was spreading and creating another infection, 2638. He introduced his relative, 2620, to the prosecution. She claimed she was raped by someone I will not name in public, and that he forced her to be his wife for over a year. And she described the alleged perpetrator, gave his first name, specified his position in the group, and said he had died in a road accident after 2014. So the prosecution showed a picture of the alleged perpetrator to her. The picture's on your screen. She couldn't recognize him. So given her very prejudicial allegation that she would have had a baby after being raped, we asked questions to prosecution witness 0888 regarding his relative who had died in a road accident. But the prosecution objected, saying the rape victim was not talking about 0888's relative. So if 2620, if the person she was referring to is not the person on your screen, with that position in Mr. Yekatom's group, who had died in a road accident after the charged crime, then who was it? Because remember, we were not the only one who came to that conclusion, that it was him. The prosecution did as well, otherwise they would not have shown that picture to 2620. But given her answer, they created another individual out of nowhere with that first name, close to Mr. Yekatom, who would also have died in a road accident. Regardless, we investigated to find her relatives. So defense witness 6010 will explain who the father is, who the father of that baby is. And he will explain that 2620 has no other child, and that the only child she has, a son, was left behind when she left Central Africa. This is how priceless it is for these witnesses to be relocated by the court. So much as to leave your own child behind and travel with another one, which is what several defense witnesses will also testify about, such as 6012 and 6019. The fact that she did not leave the country with her child is also part of our defense evidence, as you can see from the piece of evidence that's on your honor's screen. It's a Facebook message where she confirms that her child was left in Bangui with her mother, which was also a prosecution witness, 2671. Defense witnesses 6012, 6019, 6025 will show that she traveled with 2638's daughter. 2638, who had been in contact with the prosecution as early as November 2019, and who was VPRS and CLRV1's intermediary. And remember, 2638 also managed to have another of his children, this time a son, accepted as participating victim and a witness in this case. CLRV1, witness P001, who traveled all the way to The Hague to come and testify before your honors. This will also be confirmed by defense evidence. Although P001 was very insistent in denying his own identity, his real identity, even when his own picture was shown to him, with his real name next to the picture, he refused to recognize himself on that picture. But luckily, his fellow traveler, other CLRV1 witness, P002, did manage to recognize him on that picture. The evidence of all those defense witnesses is an important part of the defense case, because they not only show you that the prosecution did not meet its burden for count 29, but it also shows you how Mr. Yekatom was facing an injustice because of the extent of fabrication while the defense should have spent its time and resources finding evidence to raise a reasonable doubt on the charged crimes, the defense was instead uncovering stolen identities and fabricated documents. The defense was doing what the prosecution should have done all along. The defense was spending a considerable amount of time to disprove evidence disclosed, brought, and used by the prosecution. And this should not be the defense burden. And there's no other word than scandalous that this happened again. And it's because it's so scandalous, and because we want to preserve the integrity of these proceedings, that we will file a motion for exclusion of evidence. The defense case is also that the prosecution underestimated the value of relocation for one of the poorest countries in the world. For a witness like former prosecution witness 2620 to leave her own child behind, it shows how important relocation was. And to get relocation, the prosecution witnesses knew that their story had to be attractive for the prosecution. They had to be in a unique position, the holder of a notebook like 1339, or an insider under the age of 15, like 2475. And it's our submission, and it's part of our defense case, that the importance of relocation is also the motive behind 2475, behind his untruthful testimony and fabrication of evidence. The defense evidence will show that 2475, and this is my next topic, the defense evidence will show that 2475 was behind the fabricated baptism certificate that was submitted into evidence by the prosecution. The defense evidence will also show the collusion between 2475 and prosecution intermediary and prosecution witnesses. And to give you an overview, I want to draw your attention to the following defense evidence. It's on your screen. Remember what I said earlier. Prosecution witness 2475 knows very well that he's born in 1994, because we went back to the books in Lobai, which clearly shows his year of birth as 1994. And the accuracy of this baptism certificate that your honors have on your screen will also be confirmed by defense witness 6016 and 6018. But your honors will remember that prosecution witness 2475 insisted, when he was testifying here in court, insisted to look at the baptism certificate which was tampered with, the one that was initially shown by the prosecution. There's a reason why he was insisting. And this is what the defense evidence will show to your honors. The reason why he was insisting was because he was behind the tampering of that baptism certificate. And this is what you can now see on your honors screen. There's a Facebook exchange between him and his partner who was in the Lobai at the time. And twice he's asking her to put the year 1999, knowing very well he's born in 1994. And now there's something else that's very important. The baptism certificate submitted by the prosecution, remember, the one that's tampered with, the 1991, was given by intermediary 2580 to the prosecution, as you can see from the metadata. this Facebook conversation where 2475 is asking his partner to put 1999 occurred while the prosecution intermediary 2580 was on his prosecution mission to Lobai to collect the tampered certificate. So therefore, the exchange where the prosecution witness 2475 is specifying to his partner that the baptism should reflect the year 1999 should be enough to convince your honors that the only reasonable conclusion is that prosecution witness 2475 is behind and planned with intermediary 2580 the fabrication of his own evidence. But there's additional defense evidence that will demonstrate that little to no weight should be given to the evidence of 2475. Additional evidence that shows, Your Honor, that he was untruthful time and time again. Although he was under oath, and although you asked him to tell the truth and nothing but the truth. And I will use, in the next 5 minutes, several items of defense evidence to show you why. 2475 knew very well he was born in 94 because that's the year of birth he had put himself on his Facebook account. That Facebook account was opened in 2019. When this was put to him, and this is our submission, he also came up with another untruthful answer when confronted with his Facebook page. And he said the following: I had put 1999 because otherwise Facebook would reject, if I had put 1999, Facebook would reject the creation of the page. So that's why he had put 1994, because he was claiming Facebook had a rule and that he had he put his real year of birth, Facebook would have rejected the creation of the page. And he was quick to bring that answer. But defense evidence will show, again, that he chose to be untruthful under oath. So although he claimed that he registered under the date of 1994, because he had to make himself older because Facebook would reject the page, we know it's not true because the account was created in 1999. So whether he's 20 years old at the time or 25 years old as we know he was, Facebook would not have rejected the page. And the second reason is that in any event, the rule is 13 years old. So Facebook would not have rejected the page. You also have to remember how prosecution witness, and it's our submission, prosecution witness 2475 was very intelligent. You said it yourself. First, he wanted to reread his statement more than once to get used to it. So he pretended to be sick according to a victim's and witness message on your screen. But the defense evidence will show that he was not. Because during that period, he was publicly posting on social media videos of himself lip-singing to music and later exercising at the hotel gym during the familiarization and statement reading procedure immediately thereafter. And remember, in court, he gave a different version. He did not say he was sick. He said he was not asked to come and read the statement here at the court. That he was simply asked to go through the statement and correct any errors. There's another court rule that he didn't follow. As per the protocol, VW informs the witnesses, and this also applies to 2475, not to contact any other person from the start of the familiarization until the end of the testimony. Defense evidence will show that during his testimony, he was in contact with a prosecution witness who at the time was scheduled to testify in the coming months. And he also made sure that the upcoming witnesses would not have to face a defense examination by being confronted with various Facebook pages. You'll recall that an important part of our examination of prosecution 2475 covered his relation and knowledge of witness 2582. And I had used several Facebook pictures of her that I had showed to prosecution witness 2475. After the first day of defense examination, prosecution witness 2475, and this is what you'll see among the defense evidence, prosecution witness 2475 arranged a call with former prosecution witness 2582 through a mutual friend. This will also be part of defense evidence. In addition, within a day of the conclusion of 2475's evidence, prosecution witness 2582, who was still a prosecution witness at the time, appears to have made her publicly Facebook status private. The same pictures that I had used during my examination. Now her Facebook page was private, further evidencing collusive contact between these individuals. So it's our defense submission, and it's what we intend to show you during our defense case through several items of evidence, that 2475 communicated with 2582 about defense questioning. Because as you can see from the picture on the screen, a few days after 2475 testified, 2582 deleted the Facebook pictures that were used in court in closed session examination. This is not a coincidence. But that was not it, Mr. President, Your Honors. You will recall that during the examination of 2475, I showed him a picture of prosecution witness 2620, who was still a prosecution witness at the time. And I asked whether or not he knew that person. And once again, it's our submission. He chose not to be truthful. His answer was, I don't know her. In fact, not only did he know her very well, but defense evidence will show that 5 hours after I showed him the picture of 2620 and he claimed that he did not know her, 5 hours after, he had a minimum of 2 hours and 30-minute phone call with her. That item of evidence is on your screen. We showed you that prosecution witness 2475 had accomplices in the Lobai to help him fabricate his own baptism certificate. But he had other accomplices to inform him on defense activities to make sure we wouldn't uncover his fake story. Your Honors will remember how the main part of his alleged abduction was with another individual that I will not mention because we're in open session, but whose name is written on your Honor's screen. And surprisingly, when he came to testify, he changed that part of the story. And you even made a comment about it, Mr. President. And there's a reason for that. There's a reason why he changed that part of the story. Defense had met with this individual on 19 May 2020, as shown on defense exhibit depicted on your honor screen. But because prosecution witness 2475 was very smart, because he had prepared his plan, one of his accomplices told him on Facebook, "Please, my brother, stop connecting with people from this area." I'm not going to mention the area. "Stop connecting with people from this area. There's an investigation, you have to be careful." This message was sent about 10 days after our team met with the individual on your screen. So notice the date of that message now on your screen and the date we met the individual. This is why, and it's our submission, prosecution witness 2475 was smart enough to change his narrative on the abduction of his friend. Let's just set aside the testimony of prosecution witness 2475 and come back to the basics. The prosecution had at its disposal about 600 videos of Mr. Yekatom's group in December. This is notwithstanding the number of journalists that took pictures of Mr. Yekatom's group when they visited Mr. Yekatom's base. 2475 doesn't appear on any of those videos. Not a single one. The prosecution spent time going through some of those videos with insiders of Mr. Yekatom, some who testified, some who didn't. They went image per image, screenshot per screenshot, and they never identified 2475. Nowhere to be found. And yet again, he claims having joined the group 6 months prior to the 5th of December. You can see Manumana, Dawili, Davi, Odimba, Goliata, but you don't see the person who would have been so close to Cœur de Lion. And there's a reason why he doesn't appear in these videos. And you will hear that reason from defense witnesses. They will explain why. Defense witness 6018, 6036, 6039 will testify that while prosecution witness 2475 claims he was abducted prior to June 2013 and stayed with the Antibalaka until at least Cœur de Lion's death because nobody could leave the group. He was instead in the Lobai, living with his family and friends, attending a wedding, doing little jobs here and there. That's why he doesn't appear in those videos. And you will hear from defense witness 6036 that he did not arrive with the Antibalaka in the Lobai in January 2014. He was already there. He was hanging around them and he got to know them. The town where he was in the Lobai is a small town. Like many of those towns in the Lobai, it's one street with the mayor's office, the gendarme's post, and the market. This is why he was able to recognize certain members of Mr. Yekatom's group who were based there. He got to know the important names, such as Seda, but when it comes to how Seda died, he could not get the story right. He started to say that Mr. Yekatom was sitting in a pirogue on the river and shot at him. That's why the prosecution never asked him any questions on Seda in court, knowing very well the narrative was very wrong. Although Seda's death was quoted in the document containing the charges in the prosecution trial brief and referred to in court, the prosecution did not want to test its evidence with 2475. It appears that even the prosecution was not very confident about the evidence of 2475. Your Honors, the assessment you will make of this evidence and the decision you will take upon this basis will be part of your legacy to this court and to international justice. With the witnesses we intend to call and the evidence we intend to present for the defense of Mr. Yekatom, we're not taking anyone by surprise. You already had an overview of what is the defense case during our examination of prosecution witnesses. Our witnesses will share with you not only their experience of the events in Central Africa, but what they lived through in their communities in 2013 and 2014. Some of them will also share their interactions with Mr. Yekatom at the time of the crisis. And these testimonies and the evidence we will present go beyond the one-sided vision of the prosecution, and therefore will show that whether in public or in private, whether behind a camera or not, Mr. Yekatom did not want to violently attack the Muslim population. And as you hear the defense evidence, I ask you to keep in mind the lessons the prosecution should have learned from Lubanga. I ask you to recall the importance of testing the evidence before you so that when a doctored record is presented, it's scrutinized. I ask you to recall the importance of objectively investigating to seek the truth, so that all relevant actors are met and investigated, and not only a select few who hold up one theory. And lastly, I ask you to recall the importance of ensuring that the fairness and the integrity of these proceedings are protected, so that when falsified evidence is apparent, it's addressed and it's withdrawn. And my client, who is at the heart of this trial, trusts that you listen and assess with an open mind the evidence he brings before you in defense of the serious allegations against him. Thank you.
Thank you very much, Ms. Dimitri. This concludes our hearing today. The court is adjourned.
All rise, veuillez vous lever.